Hello and welcome to another Whitehead Mountain podcast. I'm Fariha Shams and I'm here with my colleague Sam Corse, discussing another contentious probate matter. We're discussing a new case study following on from part one that we published recently.
Hi Fariha. So this is one of Fariha's matters, which has just obviously been tweaked slightly. So the facts here are: Craig died in 2018, leaving behind a house and some personal belongings. The house had a small mortgage. Craig had no family, but had three close friends, who were James, Paul, and Angela. Craig had made a will appointing James and Paul to be his executors and wished for his estate to be divided equally between the three of James, Paul, and Angela. So soon after Craig died, James expressed his interest in buying the property and the contents, which was ultimately the whole of the estate. He offered a value for the estate, and Paul and Angela had agreed to this, and this was all prepared and signed by all of the beneficiaries. And then about 1 week after the agreement, Angela had found that the valuation James offered was much lower than the actual value of the estate, and she challenged the sale itself and the agreement. She proposed that James should pay the market value for the estate assets. Alternatively, asked that the executor should sell the assets in the open market with the view of achieving the maximum sale value. James denied this and insisted that the parties were bound by the signed agreement, and then 5 years actually passed and they still haven't reached an agreement yet. The mortgage payments are now in arrears and the lender is threatening of issuing repossession proceedings. So my first question for Ria is, what initial advice would you give to Paul here?
So Paul, as my client, would be facing two different issues here. The first issue is his responsibility as an executor or co-executor, and how would he be affected or responsible for the estate if anything goes wrong. Secondly, how is he affected by the sale as a beneficiary, as he may be losing some money from the estate if the sale continues to James, and he is not going to receive the full value for the property, or his share of the full value for the property or the estate. The initial advice would be that he needs to consider his executor's responsibilities and make sure that he's not exposed to any potential breaches by any of the beneficiaries for this undervalued sale. Although he's not benefiting anything directly from this transaction, the fact that Angela, who is another beneficiary of the estate, is challenging the sale could make or cause a major issue for Paul as a co-executor. The executors of a estate have joint and several liability, and any issues or any breaches caused by another executor, in this case being James, would directly affect Paul as well, and Paul would be equally liable for those breaches. So the main point is that he should take reasonable steps to protect the estate, and then decide whether he should continue with the transaction or not.
Well, thanks for it. What about the agreement in 2018? Is that still enforceable?
So the agreement was between the three parties to carry on with the transaction, or to sell the property and the contents to James. It wasn't a sale agreement as such, as it wasn't a transfer or a contract itself. So it was an agreement between the parties. No money changed hands, and a transfer wasn't signed for the property and the estate. And for that reason, bearing in mind the date of that agreement, it's difficult to enforce that agreement at this stage. Although the parties could face some breach of contract claim against them, and there may be some financial loss for Paul from James. The risks to Paul to face as a breach of contract claim is a lot less than being exposed to a potential claim by Angela or any other party for breach of his executor's duties. I would say, because of the date of that agreement, and the fact that it's so old now, although it may be enforceable if it goes to court, it's untenable and it's not worth continuing. So it can be challenged.
Thank
It's
you.
a vague. It's just to add on that. It's a very vague argument that could be made by either party, because it will be a matter for the court to decide based on the facts.
Thanks, Fariha. What steps should Paul take as an executor here to not only protect the estate but his own position as well?
So Paul needs to make sure that the estate is protected. So he has to act in the best interest of the estate. And selling the property to James at an undervalue is definitely not in the best interest of the estate. The main step that he can take is to apply to the court to remove James as a co-executor to stop his hindrance with the distribution of the estate. And then when another executor is appointed, or maybe in his own capacity as a sole executor, can carry on with distribution of the estate in accordance with the provisions of the will. This is one of the steps that can be taken, although he needs to take into account the costs associated with making a court application, because litigation can be quite expensive, and all funds for the litigation will be taken out of the estate. And he needs to strike a balance between the costs of applying to the court and the losses that the estate may suffer as a result of the undervalue sale. And then he should decide whether it's worth proceeding with the court application, or is it worth selling the property at an undervalue.
Well, thanks, Fariha. Interesting. Thank you for listening to the podcast again. Of course, if any of the circumstances discussed, if you can relate to them, or if you're in a similar position, or just more generally, if you have any queries at all, then please do get in touch with the Contentious Trust and Probate team here in order to have an initial meeting and obviously discuss the matter and receive comprehensive advice.